the defense.
All right, let's call the jury back then.
Get a better day.
All right. Okay. Very good. You could be seated. Thank you. Okay, thank you for returning from your lunch timely. Everybody has pen and paper. Okay, sounds good. So we're gonna begin with opening statements, Mr. Ring.
Thank you, Your Honor. Arguments. We all have arguments. We're all allowed to have arguments. It's what we do after these arguments and during those arguments to define it. We can react. Each one of us reacts in our own way. We react differently to different situations. We might call someone a name in an argument. We might storm off in an argument. We might leave in an argument. But it should be left at an argument. On May 21st, victim Pam Hartman was in an argument with the defendant. They were arguing about a toilet. They were arguing that the toilet ran too long or had been running too long. This is a constant argument. At this time, things began to get a little heated. Pam decided to leave. Pam left the house to cool off. She left the argument. The argument started, Pam left. Reaction, she left that argument. When Pam came back to the house that day, she went to her room to go to bed. It was later in the evening. The defendant was still mad about this morning. The defendant hadn't cooled off. The defendant started yelling at her. So Pam came back out of her room and another argument ensued. So now we have another argument. And they're arguing again about this broken toilet from this morning because it had been running too long. At this point, Pam decided that she was just going to leave. She was going to move out and she was going to leave. So she began to pick up her stuff. She bent down to get a computer modem out, or to get the modem out. She bent over to pick it up and she looked over and the defendant come out with a knife and began threatening her. Pam called her a couple names. It's an argument. We call people names. We do things we're not supposed to sometimes. What we can't do is we can't come at somebody with a knife because of an argument. She came at her with this knife. And she began to touch her with the knife. And she began threatening her with this knife all over a broken toilet or a toilet that wouldn't stop running. So Pam was afraid. Pam ran to her room. Pam called 911. She told 911 operator what was happening. She'd been threatened. She'd been threatened by a knife. And she hid in her room until the police arrived. The police arrived. They took apart his statements. She shouldn't have had to go and hide in her room because of an argument over a broken toilet. She shouldn't have been threatened with a knife over an argument of a broken toilet. Everybody's reaction is different, but what sets it apart is that reaction of getting a knife and coming back and threatening somebody. Ladies and gentlemen, we can't do that. Ladies and gentlemen, at the end of this, I'm going to ask you to find the defendant guilty. Thank you.
Thank you, Your Honor. Good afternoon. Once again, I only get a couple chances to talk to you guys. My name is Steve Cornish, and this is my client. This is Yvonne. And on the evening in question, the evidence is going to show that there was in fact an argument, and that was it. There was an argument, and after which my client asked the accuser, the complaining witness, if you will, to leave my client's home. Can't have you here anymore. This is multiple times now you've damaged the toilet, among other things. I need you to leave. So she left, and she comes back, and there was an argument that continued in regards to when that person would leave. Pam, if you will, complaining witness, the testimony is going to show, got upset, called the police, and made up a bunch of accusations. And ladies and gentlemen, there is zero physical evidence that an altercation occurred. So what we'll end up with is testimonial evidence. And it is believed today you will hear from the accuser all this fantastical stuff about this weapon, which upon search by the police was never found. And you'll hear all this testimony about being stabbed or poked or prodded with a weapon with no marks anywhere on the accuser. Now, ladies and gentlemen, it is true you can find a person guilty based on nothing more than testimonial evidence. The can isn't must. That's why we talked so much this morning about credibility, ladies and gentlemen. We talked about credibility, consistent statements, consistent version of events, because that's how we weigh credibility of people. Because there is no chocolate smeared cookie crumbs on somebody's face in this case. There is an accuser saying that something occurred with nothing to support that. No weapon found by the police that searched the house. No red marks from being stabbed by a knife or poked. Not necessarily piercing the skin, but maybe an abrasion or a spot. Nothing. And then we have an individual whose story has changed multiple times about when things occurred, did things occur, how things occurred. And that's what you're going to hear today. A fantastical story by somebody who was upset that they were told they could not stay in this place anymore because of the problems that they were having as roommates. Now, ladies and gentlemen, we talked a lot today about reasonable doubt. Did you know there's 3 possible things you guys can do today? 3 things that you could pick. Let's say the complaining witness gets up on the stand and she says all this stuff, and you believe her. Wow, she really does. Yeah, she's a little inconsistent, but overall, I can pick and choose what stuff the person says I believe. The judge explained that earlier. I believe her. Well, in that scenario, ladies and gentlemen, it is true that you would then find my client guilty because you believe this fantastical story. But there's a second possible thing that could happen. You see, my client's very front of you is because she has pled not guilty, and she maintains that not guilty, denying these claims against her. And you could believe that the accuser, Pam, is lying, and you could believe my client didn't do it. In which case, clearly, you would go vote not guilty. But that's where this third thing comes in. You see, we talked a little bit about that reasonable doubt and that burden of proof. The prosecutor has that burden. And so let's say that Pam gets up and she testifies. You're like, I don't know. Maybe, maybe not. So that third possibility, you believe Pam, you believe my client, or the third option, you don't know. I will tell you what, on you don't knows, the vote is not guilty. You have to believe beyond a reasonable doubt the testimony and the evidence presented to you that my client committed a crime. I'm confident when you hear the testimony, when you see what goes on here today, that you won't. I've spent a long time trying to figure out a way to explain reasonable doubt. As a young attorney, as a student, teaching other attorneys, talking to jurors. And I gotta tell you, I've relied upon it for years because it is the best explanation I've ever been able to come up with. A lot of people like Kentucky Fried Chicken. A lot of people like to go out to eat. A lot of people get food poisoning. And so you go and you order your food and you get some chicken, and it looks like golden brown like usual, and it smells like usual, but you take that bite. When you bite into that chicken, your brain in the back of your head goes, this tastes funny. That's doubt. That's your brain going, I know what chicken tastes like. I've had chicken before. This doesn't taste right. That's your brain telling you there's a doubt there. And the question becomes, is it becoming reasonable doubt? If you start tasting that chicken and it tastes worse and worse, and you keep eating that chicken, you're going to pay for it the next day, either by going to the hospital or being sick. That was you sort of listening to your reasonable doubt. And today, when you listen to the testimony and when you consider the evidence and the rules that the court will explain to you, I firmly believe that you will not get to that beyond a reasonable doubt standard. When you go back to vote, I'm going to ask you all to go back and vote not guilty. Thank you very much.
You can call your first witness.
Thank you. At this time, the people call Pamela Hartman. Conference room 2. You're gonna get her.
You stop right there and have you raise your right hand. You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under the penalty of perjury. Thank you. You can put your coat down over there if you'd like. You'll have a seat here right in the box. Okay, I have a court reporter. She's sitting directly behind you. Her job is to take down everything that's stated in the court here so she can create a record. So your responses need to be verbal. You can't do mm-hms and uh-huhs. You also can't do head nods and shakes because we can't write that into the record accurately, okay? You also need you to keep your voice up loud and clear. If you hear an objection from any of the attorneys, you would stop your response. You'll give me an opportunity to make a ruling on that objection, and then I will let you know if you can answer that question or not, okay? I want you to start by stating your first and last name and then spell both of them.
Pamela Hartman, Pamela Hartman.
You can proceed, counsel.
Thank you, Your Honor. Pam, is it okay if I call you Pam?
Yes.
Pam, back on the 21st of May, 2020, where were you living?
On Call Street with my aunt, Yvonne Hartman.
And is that address on Call Street? Is that in Lansing?
Yes.
Is that in Ingham County?
Yes.
In Michigan?
Yes.
And you said you were living there with your aunt. Is that correct?
Correct.
How long did you live there?
For a few months, I think maybe October, November. Could have been before that, September. I don't remember the month I lived in.
That's fine. It's been a long time. Were you paying rent at the time?
Yes,
And were you always on time with your rent?
yes.
And is Yvonne Hartman in the courtroom today?
Yes.
Can you please point to her and describe something she's wearing?
That's her hair's in a braid.
Let the record reflect that the witnesses identified the defendant.
Any objection to identification?
No, Your Honor.
Identification is noted.
On the morning of the 21st, what happened?
I had to go to work that day. If I recall correctly, I worked a 1:30 to 10 shift.
Was
I got up 1:30 to 10 p.m.
Thank you. I was gonna break that.
So I got up, I don't know what time. There was some issue going on with the toilet. The back of it, the tank was running. I don't know.
And had you used the toilet that morning?
Yes,
And was it, did you notice it running?
probably. I
Okay.
mean, yes,
And did it seem to run for a long amount of time?
no,
Has this toilet been an issue in the past between the
Yes.
two of you?
no, I'm sorry, no. The toilet had been an issue. There was problems with that, but not between us.
How long had the toilet been broken?
It wasn't broken. It was like the little flapper thing in the back of the tank didn't go down all the way, so it continued to run. As far as I understand the inner workings of it.
And did you speak with the defendant about the toilet on that morning?
No,
Before you went to work, did she ask you about the toilet?
yes,
Did you guys have a conversation about the toilet?
yeah, I guess. I mean, she asked me what was wrong with the toilet. I said I didn't know that it was running. She was upset. I was not going to have that argument. I continued getting ready for work, and then I left.
How did you know she was upset about the toilet?
By her demeanor and just the tone of her voice. I've known her for my whole life. I mean, I just know that she was upset, and she did say, well, a fucking toilet doesn't run that long.
And so after that, did you respond to her?
I said, I don't know what's wrong with the toilet. I didn't break it. I don't know how to fix it. I'm not a plumber. Something to that effect.
And then did you leave for work?
Yes.
Did you think about that toilet anymore while you were at work?
No.
When you came home from work, what did you do?
I came in, I walked into the house, I rounded the corner and went into my bedroom.
And you said you came in at about 10, where you got out of work at about 10:30 at night?
I got out at 10-ish, so I probably got back to the house between 10:30 and 11.
And you went straight back to your room?
Yes, when you walk in the front door, you go in, right here is that bedroom. That's where I went.
And when you walked in the front door, where was the defendant sitting?
On the couch in the living room, which is also right there.
Do you have to pass that couch to
No.
go to your room?
Nope.
Did the defendant say anything to you when you walked in?
Yes. He said, so what are you gonna do? I said, I'm gonna go to bed.
And did you proceed to go to your room?
Yes,
Did you know what she was talking about when she said,
yes, it is.
what did you think she was talking about when she said, what are you gonna do?
About where I was gonna stay, I assumed that's what she meant, about where I was going to stay, what I was going to do, because she was still upset about this toilet issue and thinking that I had somehow broken.
And did she mention that toilet again while you were going back to your room?
All she asked was what I was going to do.
And what happened after you were in your room?
She started making threats, talking just on the couch to herself, presumably loud enough so I could hear. Somebody better watch what they're doing, sleep with both eyes open, I'll gouge your fucking eyes out.
And
Those were things that she said.
you could hear it from your room?
Yes,
How far away was the couch from your
right
room?
there. Here's the bedroom door. This is where the couch is on the living room wall.
Do you have an estimate in feet?
From where I was to where she was, 15.
And your door was open?
For a moment it was, and then I shut it. So I didn't hear, it, so I wasn't listening to it.
And while she was making those comments, what were you doing?
Sitting in the bedroom, stewing, thinking about how ridiculous this was and wondering how far it was going to go.
And did you come out of the bedroom?
I did once she said she was gonna gouge my eyes out.
Why did you come out of the bedroom?
To grab my internet box. It was petty, and that's what I was doing in the moment. Fine, if you want me to take all my stuff and leave your home, then I will start with this, and you'll have no internet.
So your plan was to leave at that time?
Yes. To at least take what I could in my car and drive across town to my mom's house. That was all I was gonna do.
And when you were trying to grab that internet box, where's that internet box located?
There's the couch, there's a little table here, there's a stand right here. The internet box was underneath the tape. I'm sorry. I
So
don't
was
know
it
how to
in
describe
front, was it in front of the sofa?
To the left of it.
So could the defendant see you taking that internet box from where she sat on the
Yes,
sofa?
it was all in one room. All
Was
in
she-
one room.
Was she making any comments when you began to do that?
Just random comments about she could get me. I mean, just her little digs that she wanted to make, I could get you. She said, "I'll gouge your eyes out" a couple times.
Did she seem upset when she was making these comments?
She seemed manic. She seemed heightened, just upset. She wasn't screaming, she wasn't spitting, she wasn't up off the couch yet, but she was threatening me. And I don't know how to describe it any other way. She seemed manic and heightened.
Was this internet box located like near the ground level or
It
was
was
it?
on the
up?
ground under the table.
So you began to pick that internet box up?
Yep, I was just gonna unplug it and take it with me.
Did you unplug anything?
Just the internet box.
What happened when you began to unplug it?
That's when she got up and went into the bathroom, which the couch is along the wall, the bathroom is right behind it. Or the bathroom door is to the left of it, so then the bathroom goes behind it.
Is the bathroom, while you're getting the internet box, is the bathroom to your back?
No, it was to my left.
So the bathroom is to your left. So could you see the bathroom?
Yes, the door was open. It's not a big house. I mean, I was right there. I could see her go into the bathroom. I didn't know what she was doing when she first went in there.
And
I didn't assume
you
anything.
watched her go in, you saw her come back out.
Yeah,
What happened?
she had a knife in her hand. It was a dagger. It's something that it's always been in the house. In the bathroom, there's access to underneath the house, the basement, where I don't know what it is. Like when there was a backup with the toilet, that's where the guy had to get
Okay.
into to fix that stuff. And that's the thing that she used to get this big back door.
So it's,
Just a piece of wood that's in there that sits on the floor. It covers the
and
access.
she had this knife in her hand
Yep. And
that she uses to pry open a floor, basically a floorboard
Yeah.
to get access to underneath the house. And do you recall what hand it was in? That's fine. It's been a while. And how was she holding it when she went?
She
and
just
grabbed
had it in her hand at that point. Well, when she walked over to me while I was still on the floor, trying to get this stupid router or the modem or whatever it is, the cable or the internet box, trying to get that. Then she walked over and sat there, and that's when she said again, "Bitch, I'll gouge your fucking eyes out."
And when she said that to you, how was she holding the knife?
Just still in her hand. I mean, I guess kind of wasn't jabbing it at me. She didn't have it over her head. I mean, she just had it in her hand. I had my phone in my hand, so that's when I called 911.
But the record reflected that the witness was holding her hand up in a forward facing position where a knife would be.
So noted.
And so at that time, she had a knife
Mhm.
and she was making threats to you.
Yeah.
What were you feeling in that moment?
Then I was scared. She's never held a knife on me before. I've never had somebody at me with a dagger in their hand, talking about how they're gonna gouge my eyes out, especially over a toilet, and putting it in front of me.
Did you know what to do in that moment?
I called 911. That's the only thing I could think of because I did have my phone in my hand. So while I was on the phone, I continued to try and unplug this stupid box. And then it got to the point where I was facing more towards the bathroom. I had turned slightly to my left. That's when she took the knife and held it to my arm. She did not stab me. She didn't jab it in. She just held it there and continued to make threats about how I need to sleep with one eye or both eyes open. She's gonna gouge my eyes out.
How was the knife positioned on your arm?
She had it in her hand and was holding it. I mean, like this. I don't know what hand it was, but she was holding it like this and just It was touching my arm.
Was the tip of the knife touching your arm, or
Yes.
the blade of the knife, or the handle?
The tip of it was touching my arm.
And at that time, you called 911?
Oh, I was already on the phone at that point. I said, she's got a knife.
And at some point,
I stood up. There was a chair between us now, because she's got a small dining room table. There was a chair between us. I was still on the phone. I don't remember exactly what I was saying. Then I pushed the chair.
why did you push the chair?
So stupid. You see it in TV. I felt like I could push it and it would give me a minute to get back into the bed.
So you pushed the chair while you're
I just pushed
retreating,
the chair down and went back.
while you're
Yes.
retreating to your bedroom?
Yes,
Did you make it to your bedroom?
yes. There's
What?
She followed
Did
with
you-
that knife in her hand.
Was she holding the knife at her side? How was she holding the knife when she followed? Was it still pointing out towards
Still
you?
pointing out, but not, I mean, it wasn't over her head. It was just, she was pointing it out, coming towards the door. I got to the door and it's that door only there's a middle panel, it's glass, like a front door that got put on a back.
So you could see her through the glass? And what was she doing while you were on the other
Trying
side
to
of the
push the
door?
door open while I sat against the wooden frame part of it and talked to the person on 911.
Was she still making threats at that
Yes.
time? Was she
Yes.
banging on the door?
She was trying to push it open. She wasn't necessarily punching and hitting it, but she was trying to push it open while I sat against it with my feet raised on my back so that she couldn't open the door. But I was worried that she was going to break the glass. It's her house. You can do whatever she wants.
Did she break the glass?
No.
Did she get into your room?
No, because she went and sat back down on the couch. And she sat there and continued talking and just saying things and till there was a knock on the door.
And
then
what
she
happened, what happened with the knock on the door?
She said, "Oh, your little friends are here. You might want to go get that."
Who was at the door?
Please. I could see them through the bedroom window, which was right by the, which was like the porch. When you come up on the porch, there's a bedroom, and there's a door. So I could see from my bedroom that it was the police. So I got up and I opened the door. They asked me to come outside. So
You spoke with police, gave them a statement,
I gave them a statement.
told them what happened. Yeah.
And then stood around. I said that I had
That's-
called 911.
Your Honor, at this time, I would like to publish,
Alright.
request permission to publish the 911 call that's been stipulated to by the defense.
Okay, do so at this time.
My speakers aren't working.
Just a cord.
My speakers aren't working at this time.
Okay. Yeah, I'm at 916 Call Street and I need officers here. I'm being threatened in my home. By the homeowner. It's my aunt. I've been living here since fucking September. Okay. Since September. What's your name? Pam Hartman. What's your first name? Pam. 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 P-A-M. Oh, Pam. Sorry. And who's your aunt? Yvonne Hartman. And verbally? Physically? Yeah. She hasn't gotten physical yet with this, but she does, so. Okay. Any weapons at the residence? She's got plenty of knives, and she's fucking crazy. So. How old is she? How old is she? Sorry? How old is she? 60. 50? 60. 60. Phone number you're calling from? 517-554. Is anyone there under public health monitoring for COVID-19? I'm sorry? Anyone under monitoring for COVID-19? I don't think so. I'm not, no. Okay. Anybody have a fever? I'm sorry? Anyone said she's gonna kill me. She just said she's gonna kill me and she's gonna fucking kill me! She's gonna die! She's gonna me! She's gonna die! Okay, I can hear you, ma'am. Can you walk? Get the fuck away from me! She's gonna die! Can you walk out of the house? Ma'am, can you walk outside the house? I can't! I'm stuck in my bedroom! She's got a knife! Can you shut the door of your bedroom? I just got a glass in it! She just hit me with that fucking knife! Can you go into another room? No, I'm stuck in here! Where's here? In my bedroom. Can the door be shut or no? It is shut. Okay, she outside it? Yes. Okay. I need somebody here. I put in a call for you. Ma'am. Didn't you say she... You got it! I need somebody here! Aren't you able to shut? I can't leave. She's shooting us in the bedroom. I need somebody here. Jesus is wrecking my life. Aren't you able to shut your bedroom door? It is shut, but it doesn't have a lock. Can you put something against it so she can't get in? No. No. The bed? A dresser? I can't move the bed. I don't have a dresser. You sit behind it so she can't open the door. It's a glass front door. The bedroom is a glass door. Yeah. It was a spare bedroom. Okay, are you able? Yeah. I need somebody here. I have a call put in for you. They have to drive there. I'll keep you on the phone. Did she walk away from you? No. Okay. She's coming back and she's standing there going, get out of my house. She's got that fucking knife in her hand. What kind of knife does she have? It's like some old dagger style thing. She usually uses it to open the basement hatch. Okay. You have to go into the floor. And you've been living there since last year? Yeah. How do you spell her first name? Do you know? Yvomme. Again, Yzomme. Are they gonna be here soon? As soon as they're driving there. Outside the bedroom in the living room. Right outside the bedroom. Right outside your bedroom. Yeah. Okay. These elders let me. They'll be there shortly. Take care of it.
Let the record reflect that I'm stopping at 6 minutes and 45 seconds. Tammy, we heard the call. How are you feeling during that call?
Now,
During when it was
then,
Yeah.
I was terrified then.
officers and shit.
They did.
No further questions. Thank you, Your Honor.
Cross-examination.
Thank you. Good afternoon. Got a couple of follow-up questions for you, okay, Pam?
Sure.
What I'd like you to do is listen to my question and answer them as questions. Is that okay?
Yes.
Okay. If you don't understand something, you can just say I don't understand or ask me to rephrase it. Is that okay? Thank you. Now, you stated earlier that you and Yvonne started arguing before you left for work. Is that correct?
Yes, it is.
And your testimony today is it was only in regards to a toilet. Is that correct?
Correct.
Wasn't any issue of drugs or anything?
Absolutely not.
You got home sometime between 10 and 11 p.m.
Yes.
Now, when you arrived home, your earlier testimony was that you decided you were going to move out. Is that correct? Okay. So would it then be correct that my client asked you to move out?
No.
Told you to move out?
No. There was no discussion of moving out.
At some point, you made that decision and decided to get your
I decided
box,
that I was going to leave, yes.
and you went to collect your modem box.
Correct.
It's called the general internet box for today. The box was something you had in your name.
Correct.
And we just heard a snippet of the 911 call. Is that correct?
Correct.
During the 911 call, you stayed on the phone with that operator from the entire link, from when we first hear all the way until the police arrive. Is that correct?
Correct.
And would you say my client was loud and screaming at you during that 911 call?
She was loud, yes.
I think you previously had testified that she was very loud. Is that accurate?
Correct.
And on the night in question, you made a statement to the police. Is that also correct?
Yes.
Now, earlier, you testified you were kneeling down, let's say unplugging your device, correct?
Yes.
My client retrieved a dagger, you called it, correct?
Correct.
Held the dagger up to you on your arm,
Correct.
and you had a phone in your hand, so you called 911. Is that correct?
Correct.
That was your testimony just a
That
few
was
minutes ago.
correct,
That's your
yeah.
recollection of events.
Yes.
You were just listening to the 911 call, correct?
Yes.
And one of the very first things that the 911 operator asked you is, had this become physical? Isn't that correct?
Correct.
And you denied it. You said no.
That is correct. So,
That's the only question. In fact, you didn't at any time during that initial conversation with that 911 operator say she has a knife. That initial part there.
correct.
But today your testimony is she had the knife before you called.
That is what I said.
And you didn't say she's attacking me when she said, is there any physical assault here?
Correct.
You didn't say she's threatening to stab me.
That's correct.
She's poking me with a knife.
That's correct.
Have you previously said she was poking you with the knife?
She
though?
did poke me with the knife. She poked my arm
Okay.
with the knife. She didn't stab me. She poked me with the knife.
Okay. So when you say dagger, you mean like a pointed,
It is a dagger. Yes, it has the hilt is long. I don't know how big it is.
but it comes to a point.
Correct. It's rusty and it comes to a point. It's old.
Is it sharp?
Sharp enough to stab someone? Yes.
There was no marks on you that night.
There were not.
She poked you at least 3 times in the arm. Isn't that correct?
That's correct.
That's what you told the police anyway.
Yes.
You didn't tell the 911 operator she's stabbing you with the knife
She wasn't stabbing me.
or poking you with the knife.
I said she has a knife. I don't believe I used those words. No, you are correct.
When the operator at the beginning of the phone call, which is occurring after you've already claimed today on testimony on direct, that's when the prosecutor goes. After she's held the knife to you or poked you in the arm with the knife, you then called the police as your testimony today. That's what you testified to on direct, correct? Is that a yes?
Yes.
But I only asked that because she's recording. But we all heard the call. And you denied that to the 911 operator. Did you not at the beginning of that phone call when she asked?
I did. I made a mistake. You are correct.
Well, Now, you testified that during the 911 call, my client was screaming at you. Do you remember testifying to that before?
Yes.
We just listened to that 911 phone call.
Correct.
Did we hear my client screaming at you on that phone call?
You could hear her through a closed door, so I would say yes.
You said she was threatening you.
Yes, she was.
During that 911
Yes,
call,
she
you
was.
said she was
Absolutely.
threatened to, I believe you said, gouge your eyes out.
No, she said I will gouge your fucking eyes out. That is what she said.
Now, and again, this entire thing occurred while you were on the phone with 911. Is that correct?
Correct.
Did she threaten to break windows?
Yeah. She said she could break the window because it's her house and she can do what she wants.
And that was during the 911.
That's while I was on the call. Apparently, she didn't scream loud enough to be heard on my phone through a closed door. That doesn't mean it didn't happen. This was also 2.5
And there's no question
years
before you
ago.
go. Well, let's go to that. 2.5 years ago, you testified about this, didn't you?
Yeah,
Under oath.
yes,
Swore to tell the truth.
yes,
And this is questions I'm asking you from that last time we testified. Remember that?
yes. And if I've gotten the timeline messed up, it's because it's been 2.5 years.
Would you agree that 2.5 years ago when you testified it was fresh in your mind?
Yes,
So ma'am, 2.5 years ago when you testified, isn't it true? You testified the same way you're testifying today.
upset?
No.
Absolutely.
You testified 2.5 years ago.
I'm telling it as I remember it 2.5 years ago, yes,
2.5 years ago, you testified under oath.
yes,
When you testified under oath 2.5 years ago, you said she was screaming at you.
okay,
Is that a yes?
yes.
Okay.
Screaming, yelling, it's the same thing as far as I'm concerned in the context of this evening.
And 2.5 years ago, you testified under oath that she poked you or came at you with a knife, and then you called 911 afterwards.
Okay,
Is that a
Is that
yes?
a yes?
yes,
So it's not a difference in time. You're testifying the same way you testified previously. It's a difference in your story. Isn't that true?
no, that is not true. That is not true.
Okay. First witness, Your Honor.
Okay.
I'm going to hand you a copy of your previous testimony. Okay, I've highlighted a couple of things. If you could look down and read it, and look up when you're done. Yourself, sorry. You would agree when this was fresh in your mind 2.5 years ago, your statement is inconsistent with the 911 call, isn't that correct?
We couldn't hear you.
No. That night happened the way I testified to it. That's it. That's what happened.
Ma'am, you told the 911 operator she's not got a weapon. And
Then I
twice-
made a mistake at some point because she went and got that knife from the bathroom and she held it on me and she threatened me. I'm sorry that the timeline wasn't perfect, but that's what happened. You did what you did.
Ma'am,
She did what she did.
there's no question for you about that. My question is, 2.5 years ago when this was fresh in your mind, like, recent to the alleged incident, you testified she had the knife before you called 911,
Then she had the knife before I called 911.
that she assaulted you with the knife.
If that's what being poked in the arm is, then yes, she assaulted me. I was
We
in
all
fear
just-
for my life while
Ma'am,
she had
ma'am,
that knife in her
We
hand.
all just listened to the call,
Okay,
and she didn't have a weapon when you called 911. Correct?
apparently.
Yeah. Your testimony today is that you pushed over a dining room chair
I pushed the chair, yes. I pushed the chair out of the way, yes.
because my client was chasing after you with this knife.
She wasn't chasing me at that point. I pushed the knife or I pushed the chair so that I could get into the bedroom so I could slow her down from coming at me because we were both standing at that point.
And your testimony is that at some point she was chasing after you?
When I went into the bedroom, yes, because I didn't throw the chair at her. I didn't knock it over even. I just kind of pushed it into her. She came after and she followed me to the bedroom. She wasn't running. The house isn't that big. She didn't have to. But she had that knife in her hand. It was what it was.
Is there a curtain on your door?
No. There was one on the bedroom window. I'll be honest with you, I don't remember. I don't remember if there was. There might have been a white one at one point. I don't remember if it stayed up the whole time. I just don't remember. Like I said, it's been 2.5 years. I don't spend every day thinking about this.
You said that my client continuously said, "I'll cut you," while on the phone with 911. Or I'll fucking cut you.
Whatever the threats were that she made, yes, that's what she said. Whatever I testified to, yes.
Isn't it true on the call? You can hear what she says.
No,
You
It's
can
not.
hear her say on that call we all just listened to, "You've got to get out of my house."
that's the only thing you could hear. Yes. I
You could
will say
clearly
that.
hear. I will not have you calling me names. You could clearly hear her say that.
Crazy is the name.
And
so
she
yes.
wasn't screaming. She was talking at a calm level voice of, "You got to get out of my house."
No, she was not. No,
You could hear that call, could you not?
and that was through a closed door.
And that's the only statement you could hear her say.
That's the only statement you could hear her say.
So you can hear her on that phone call that we all just listened to
Yes.
threaten you. Say,
Now,
"I'm going to scream at you." Your testimony is scream at you is what you
No, you
testified to.
couldn't.
as.
when I came in here, honestly, I thought that call would make my case.
But you
I
can,
was ready for that to be submitted, and you were gonna sit there and have nothing left to say. And she would know how this was going to end. And then I heard the call, and it doesn't make my case the way it should, because she did what she did and she said what she said. You can ask me every different way that you want. It's not going to change. She threatened me. I don't know. 2.5 years later, I don't remember exactly when she picked up the knife, but she picked up the knife and she held it to me and she threatened me repeatedly through the door while I was on the phone. Just because you
Ma'am.
can't hear it doesn't mean it didn't
Ma'am,
happen.
That's
ma'am,
enough.
there's no
Let's-
question on the floor, okay?
Let's be clear. The police searched my client's house. Isn't that true?
Yep,
They went through my client's house. They went through my client's bedroom.
they did not.
Were you in the house?
Nope. But
So
they
you don't
told-
know.
They told me they didn't, so,
So objection, that's hearsay. You don't know,
okay,
right? You don't know what they searched.
correct.
So if I showed you video of the cops going through my client's bedroom just because one cop said he didn't do it, another cop did it, that cop didn't do it,
I'll guarantee,
correct?
I'll guarantee you he didn't pick up the mattress to her bed. That's what the
Madam?
video will show you.
The cops searched my client's house.
And I found the knife as soon as they left.
The objection, Your Honor.
I did.
Objection, ma'am, that's, you're to let me respond to the objection, okay?
Okay.
Did you want to respond to this objection?
I don't think you can object to his own question.
It's
Your Honor.
non-responsive. I
He's
absolutely can't.
he's objecting to her response.
I have a response.
Okay, the objection is granted. That response is stricken.
Thank you, Your Honor. The cops searched my client's bedroom and searched my client's house. Correct?
I wasn't there.
They brought multiple items out to you to show you. Isn't that correct?
They brought a couple knives out, correct?
Basically every knife in the kitchen that they found.
That is incorrect. They brought me a couple kitchen knives and asked if that was it, and I said it was not. I explained what the bag looked like.
They bring anything else out to you?
And I don't remember.
You don't remember them bringing out like a, not a knife, but like a putty tool?
I don't remember exactly what they brought out, but they didn't bring out the weapon that she used.
You have no recollection of a putty tool with a black handle that's used to open the bathroom hatch?
Specifically, no. Because that's not what she used to open that hatch.
There's no question for you, ma'am. Yeah, no, that's the insurance. Thank you.
Redirect.
Thank you, Your Honor.
Ma'am,
Why didn't you tell the operator initially that she had a knife?
She probably didn't have it in her hand. I don't remember the exact order of everything.
You started to explain it a little bit, so.
I don't know. All I remember is being on the phone with 911 and she had that knife on my arm. I don't remember exactly when she picked it up, if it was before or after, but I know she was threatening me. I just wanted to get out of her house at that point.
Is it a pretty stressful situation?
Yes,
A lot of things happening at once.
yeah. But
Anything like this ever happened to you before?
like this, no.
On the 911 call, you did hear some noise in the background, some yelling. Who was doing that?
She was, Yvonne was.
It was loud enough that the 911 call picked it up, right?
Some of it, yes.
Is that when she was making threats to you?
Yes.
Have you looked at your testimony since the last time you testified in court?
No, I have not.
Have you read it?
No.
So you're testifying today by what you remember from 2 years ago.
2.5 years ago, yes.
No further questions this time, Your Honor.
May this witness be excused?
Yes, Your Honor.
yes, Your Honor.
Thank you, ma'am. You may be excused. You can call your next witness.
If people have no further witnesses, it's time, Your Honor, people rest.
Take a brief break, 5 minutes, let the jury stretch a little bit, maybe get a snack. All right.
You have the right to remain silent. You do not have to testify.
Yes.
And you would like to waive that right and take the stand, is that correct? Nobody's forcing you or threatening you?
Okay, you understand that if you take the stand, that you now give the prosecution the right to cross-examine you, ma'am?
Yes.
Okay. Jury back, please. You all approve this one.
Perfect, yes.
I got a better one. I'm proud of you. You better. So look at the ingredients for you. Okay, we have everybody back. And you can be seated. Okay, defense, prepare your witness.
Thank you, Your Honor. Your Honor, this time the defense would call Yvonne Hartman.
You wanna step right there and then raise your right hand for me, okay? You come right around. You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury.
Yes.
Okay, you can have a seat there, ma'am. Now I'll repeat some of the rules for you. You need to make sure your responses are verbal and loud and clear so that the court recorder can hear you. So you want to say yes and no and not use head nods and head shakes or mhm and uhs because those are difficult to understand in the record, okay?
Yeah.
If you hear an objection by any of the attorneys, you would stop speaking. I'll make a ruling on that objection and I'll let you know if you can respond. Counsel, you can proceed.
Thank you, Yvonne. Can I take you back to that night in question? I believe it was either the 20th or the 21st of May of 2020. Do you remember that day?
Yes.
Remember any sort of argument you may have had with your niece?
Yes.
Your niece is Pam.
Yes.
Watched her testify earlier.
Yes.
Was she living with you at the time?
Yes.
Now, do you recall what you guys were arguing about that day?
Yes.
Could you kind of fill us in on what that was?
Well, I had trouble with my toilet and she was in the bathroom and that, left the bathroom and the toilet was running. And so I brought it to her attention and asked her to go fix it. And why, because
Is it the first time that there have been issues since she moved in with the toilet?
no, before I had to have a plumber come 2 times over Tampons in the toilet.
Was there anything else the two of you were having a disagreement about?
Yes.
Tell us what that was.
She was doing drugs in her bedroom. She had a big propane or butane and she was doing drugs in the bedroom and that. And plain and simple, I just told her that enough was enough.
When you say enough is enough, what do you mean?
I didn't want her doing that no more. She was destroying stuff and I thought she was gonna burn my house down. I mean, I woke up once to a big cloud of smoke.
Did you ask her to leave?
Yes, I did. Told her she had to move. We had an agreement when she moved in that if it didn't work out, she would move. No questions. And it wasn't working out. I asked her to move and she got upset.
Now, we all heard that 911 phone call. You heard that, is that correct?
Yes.
Any point during that 911 phone call, could you hear yourself make any kind of threats?
No.
Did you make any threats?
No, I did not.
And we've been hearing all these stories about this knife. Do you own a some sized black dagger Dirk stiletto?
Not at all.
There is in fact a hatch in your bathroom, is that true?
There's not a hatch. It would, I don't know what it's access to the basement.
And do you have anything that you use to open that up with?
A 5-in-1 tool. It's like a putty knife.
Just gonna say, help me understand what that is. And that's maybe 3 to 5, about, that's like about 5 inches, is that accurate?
Yeah,
maybe,
if that.
okay, and that does not come to a sharp point, is that correct?
No.
Thank you. Now, we heard her screaming on that video.
Yeah.
Was she acting like that while you were in the room with her?
From what my version of this is, she came home, I had to get up and unlock the door for her. I let her in, and she was going to her room, which that's what she usually did. And all I did was say, Pam, what are you gonna do? And, I'll give you until the 1st, and you have to move. And she went in the bedroom, and next thing I know, I heard her talking on the phone. I guess she was talking to the police. And from there, that's when she was talking to the police and going, you heard her.
Were you screaming as she says?
No,
No. Have you ever threatened her with them?
never. I've never threatened her at all. Never. Never harmed her.
Can you take me through this chair thing that she was talking about, pushing over a chair or something? Can you explain that to me, what occurred there?
She picked a chair up and threw it.
When the police got there, that was still on the floor, is that correct?
Yes.
Did you try and get into her room at some point?
No.
What kind of door is on that room?
It's a regular door, but there's a glass in it. It was an office at one point, but there is a curtain on it. You can't see in it. In fact, I still have the curtain that I put on there for the room.
Did you chase anybody around? Can you chase anybody around?
No,
Why not?
or would I, well, physically, I don't think I'm up to chasing anybody.
In fact, do you have one lung? Is that accurate?
Yes,
You're using an inhaler, is that accurate?
yes.
Now, the night in question, you remained in your house the entire time until you left, is that correct?
Yes, I did.
Throughout this whole process.
Yes,
Were you there when the police came?
yes, I was.
Did you let the police into your home?
No, I told Pam to go to the door. I had to tell her several times that somebody was at the door to go get the door.
Where were you when that was occurring?
On my couch.
At some point, did you allow the police in? I guess is a more accurate question. Did you say, come on in or come
Oh,
in?
yeah, because they told me to come outdoors and I said, no, come on in. And so they came in.
You invited the police in.
Yeah.
And while you were present, did they search your home?
Yes, they did. They went all through my house. They even looked in the refrigerator. The only room they didn't go in was Pamela's.
Did you offer them to go into Pamela's room?
Yeah, I told them to. Please do. I wanted them to.
Is that where you were known to have seen her with? I want to be clear. You never saw her with drugs. Is that accurate?
Well, I haven't didn't exactly see the drugs,
You saw some sort of torch thing.
but I seen the butane, spoons that were bent. And, like I said, clouds of smoke. I woke up and I honestly thought my house was on fire one night, and she thought it was all a joke. And when I told her no more of the butane stuff, that really got her upset. I told her there wasn't, because I let her go. I did smell the marijuana, and which I didn't mind. She's in her room. So be it. Better than on the street. But when she was using a butane, no, that was that was enough.
Would you agree that no weapon was found in your home?
Yes.
Is that because there is no such thing as a
No.
weapon? You ever threatened to gouge her eyeballs out? You ever threatened anybody to gouge her eyeballs out?
No,
What about cut her?
no,
Curse at her?
no.
In fact, you listened to the 911 call, correct?
Yes, I did.
And could you hear yourself on the 911 call asking her to move out?
No.
Would you agree you could hear yourself in the background saying something?
Yeah, I heard something. The TV was on too, but yes, I did hear. I did tell her to move, especially when I found out she was on the phone to the police. I said, now you really gotta go. I mean, it's just,
You talked to the police that night, correct?
yes, I did.
You gave them a statement.
Yes,
Have you changed what you've said to them to what you're telling me today?
no.
Thank you, Your Honor.
Cross-examination.
Thank you, Your Honor. You argued with Pam in the morning before she left for work about the toilet, right?
Yeah, it wasn't really an argument, just, hey,
And she went to work and you stayed home, right? And when she came back, you started it back up, right?
started what?
The argument back up,
No.
right?
No, I did not.
You didn't say anything to her when she came in?
Yeah, I asked her what she was gonna do and, told her that,
You couldn't just leave it alone?
no, I wanted.
You were pretty mad about that toilet, weren't you?
Well, yeah, I had a lot of money
Pretty-
put
pretty
into that,
upset.
$400.
Pretty upset, right? It's upsetting to you?
Yeah.
You yelled at her, didn't you?
No,
We heard on the 911 call that background noise of you yelling. That was you yelling in the
I did
beginning of
not
it.
yell.
You didn't tell the police she almost burnt the house down, did you?
Not that time. I
This-
did.
this is the
No,
first
I
time
did
that- So this is the first time anybody's hearing that she almost burnt the house down, correct?
not. Yeah, because that was a whole different occasion there.
That-
Well, yeah, I probably told the one officer
That
when I was
putty,
telling her what was going on.
that
I
putty
told her
knife,
everything.
the putty knife that you said you used to pry the hatch open. This points on the end, doesn't it?
No,
It's rounded,
no, it's straight,
doesn't have a
just like a
corner,
putty knife.
doesn't have a corner on each end.
It's got
point
like
on each
a
end?
bottle opener, like, you could use it for a bottle opener, like, it does like 5 things.
Why didn't you answer the door when
Maybe
police?
more.
Why didn't you answer the door when police came?
Cause I was sitting watching TV and I didn't call anybody
You
and
were-
didn't have no reason to answer the door. I didn't,
You were
Expect
closest to the door, right?
well, not close enough where I wanted to get up and disturb myself.
Somebody comes to the door, you didn't answer.
It was for her.
Pam called you a name, didn't she?
Yeah, she has a real good vocabulary of words.
You didn't like that either, did you?
No, I don't.
That made you pretty mad too, didn't you?
No need for,
How many times have you reviewed your police report?
excuse me,
How many times have you looked at the police report?
maybe once when I was at my lawyer's.
In the last almost 3 years, you've only looked at the police report once?
Pretty much, yeah.
Have you,
When I went,
you
whenever I was
reviewed-
at the office there, we never even,
have you reviewed Pam's testimony
no,
from the first preliminary exam?
no,
Did you sit at the defense table in the first exam when she testified?
yes,
You heard her testimony?
yes.
And you just wanted her out of your house, right?
Yes,
But you just said yourself, you only threatened to throw her out. She really needed to go out when she called 911.
I didn't threaten her. It was an agreement we had. Things weren't working out. And I just told her it was time to move.
Well, on
And
direct,
she
you
did
said,
not like that.
on
And
direct,
that's when she got mad
oh,
and called the
ma'am,
police.
on direct, you said, you really did it now. You need to get out when she called 911.
Oh, yeah, when she was on the phone calling the police, that's it, that's
So-
it. Final, done. It's a
You
wrap.
retaliated from her calling the police, threatening to throw her out finally.
No, I told her that way before that she had to move.
But you told her again, for real.
And there
Now-
was no throw out.
Now that she called 911, she has to go. No further questions, Your Honor. Thank you.
Redirect.
Very briefly. One of the questions that was asked is, this is the first time today that magically you've come up with, I'm paraphrasing, magically you've come up with this story about these torches and spoons. Did you hear that question?
Yes, I did.
If I showed you a copy of your statement you made to the police, would that refresh your memory about what you said the night in question?
Yes.
Could I approach Your Honor?
Okay.
If you could just read this highlighted part to yourself and look up when you're done.
Oh, which I highlighted.
I'm so sorry. Give me 1 second.
Oh.
Now you've had a chance to look at that refresh your memory about what your statement to the police was 2.5 years ago?
Yeah,
Did you in fact tell the police 2.5 years ago the same thing you told me on direct today?
yes,
That you were concerned about not just the toilet, but also about the fact that there was these spoons and torches and butane things in the room?
yes,
That's not something you made up for today's hearing.
no,
You told that to Officer Miller,
yes,
who's conspicuously not here today. Is that correct?
yes,
And Officer Miller sat there the whole time when they searched your house.
yes,
That's the same officer.
yes,
You told Pam before she left for work she needed to move out.
yes, I did.
When she got home, you asked her, when are you leaving, basically? I'm paraphrasing.
Exactly.
Wasn't because she called the police, you asked her to leave. Is that correct?
No, no, but.
In fact, you didn't try and do a forceful eviction on her. You asked her to leave, and eventually, after she called the police, did she leave?
No, and in fact, I gave her until the first. That was like 2 weeks.
But eventually, she moved out.
Yeah,
You're not living together with her still.
no. Nope.
Were you so mad about a plugged toilet that you would try and stab somebody with a knife?
No,
You ever been that mad in your life?
no, no.
What about threatening somebody with a knife? A knife that doesn't exist, correct?
Correct.
You know. Known Pam her whole life?
Yeah.
Is she prone to emotional outbursts like that?
Yes, ever since she was a little girl, she used to do that, and she could just turn it on and turn it off. And I guess, I don't know, I just looked at her as that little girl and took care of her, brought her into my home, because she was living in her car.
How does it make you feel to be falsely accused of something like this?
I'm very hurt that Pamela would accuse me of such thing, and, you know, just, I can't believe she made up such a story.
Thank you, Your Honor. Nothing further.
Ms. Hartman, you may be excused from the stand. Will the defense be calling any other witnesses?
No, Your Honor, that's right.
Rebuttal witness.
Not this time, thank you, Your Honor.
Thank you. So both the people and the defense are going to rest. Is that correct?
That is correct, Your Honor.
Okay, sounds good. Okay, well, you all are gonna get another break because we need to go over some housekeeping things and then we're going to give you your opportunity to deliberate. I don't think we need too much time, so let's just give you a 5-minute break and then we'll come back. We'll do closing arguments and then final jury instructions, okay? All right. Leave your notes here.
Oh, okay.
You're not free to deliberate at this time.
Got it. Sorry.
Okay. Now you can be seated. We're going to proceed to closing arguments. Mr. Reed, you can begin.
Thank you, Your Honor. This. We talked about reactions. Reactions to situation. And the different people have different reactions to different things. Discuss, I told you about the lead up to this. Pam got up here. She testified. And she told you the story as she remembers it. She told you what happened to her. She told you that they argued about this toilet floor in the morning when she left for work. And when she got home from work, the defendant started the argument back up again. The defendant's reaction after that was to go in and to get a knife and to come back out with a knife. Pam's reaction, she said it herself. She told you, I was petty. I was petty at the time. I was going to get my internet because I was being petty. Getting your internet box isn't against the law. Being petty isn't a crime. It's a reaction that everyone, that all of us could have at any given time. She got up here and defense asked her a bunch of questions about the last time she testified. She would tell you she couldn't remember, or she might have said it that way. She was up here to lie to you. She would have told that story exactly the same way she told it the first time. That's not what happened today. She come up here and she told you what happened, and it might not be the exact same as it was the first time. It's been nearly 3 years since this incident took place. Things change. People's memories change. People tend to try to let go. Some people don't let go. You heard the 911 tape. You could hear somebody yelling, being belligerent in the background. You could hear the screaming. And you could hear the fear in Pam's voice when somebody come out with a knife. You could hear how she was afraid. And then you could hear from there how the fear drove her reaction. You heard from her that she went into her bedroom to hide. You heard that she didn't have anything that she could put up against that door to block her from coming in if she wanted to, because the door didn't have a lock on it. You heard the 911 operator ask her if she could sit against the door. So there she sat, scared against the door. Somebody on the other side of that door with a knife. Ladies and gentlemen, taking all the evidence together, I have 2 elements to meet in this case. First, the defendant attempted to commit a battery or an act that would cause a reasonable person to fear or apprehend an immediate battery. A battery being a forceful, violent, or offensive touching of the person or something closely connected to that person. Second, the defendant intended to commit a battery. Oh, sorry, 3 elements. And third, that the defendant had the ability to commit that. The defendant intended to make her afraid. She came at her with a knife. Her intent is inferred by her actions. Her actions were to go get a knife. She meant for Pam to be afraid. Ladies and gentlemen, taking all of that, I have met my burden of proof beyond a reasonable doubt. There should be no reasonable doubt in your mind that she did commit an assault against Pam. So at this time, ladies and gentlemen, I will ask you to find the defendant guilty. Thank you.
Thank you. Good afternoon, ladies and gentlemen. I want to clear up a couple of things that were stated by the prosecution in this closing. Questioning of Hartman was in regards to not necessarily her prior inconsistent testimony from shortly after this incident is alleged to have occurred, but from her statement that she gave to the police the night in question, and how that changed at that first hearing under oath when she testified. Those statements, which are wildly different, were different back then. So this whole 3 years ago, 2.5 years ago, argument that's being made about today's testimony is a red herring, as they say. The difference was back then, and it remained different today. Her statement was that my client grabbed a knife from the bathroom, poked her with it in the arm. This is from the night in question. Then she had her phone in her hand and called 911. Ladies and gentlemen, you all listened to a very dramatic 911 phone call from a witness who is prone to those things. And I don't want to digress on this, but you can hear in her voice, she's upset, she's screaming, she's crying. It switches. It's Pam, P-A-M. Then it's back to crying and upset and terrified sounding, I say. Because anybody who has a sibling, has a parent, has a friend, somebody who's been in trouble can tell when somebody's faking. But we don't have to take that. We can take her own word.
Yvonne Hartman. And verbally, physically? Yeah. She hasn't gotten physically yet, but she does, so.
She hasn't gotten physical yet. She's on the phone with 911. Not she was poked or stabbed or touched with a weapon and then called 911 as she claims. Because she's lying. And she thinks the tears will make you believe it. I'm going to tell you, anybody who has a child, anybody who's been around a niece or a nephew knows when they get in trouble that they can just turn that fountain on, that they can just start crying. Ladies and gentlemen, I told you before we started, if you buy into her story, and I understand, she sounds dramatic on that 911 call. But she said, and I quote, that my client was threatening to cut her effing or fucking her eyes out. You didn't hear that on the call. You heard my client say you gotta go. And she wasn't screaming and screeching. My client's got one lung, for goodness gracious. She's on an inhaler. She isn't chasing some young lady around the house trying to stab her. She's kicking her out of the house because she can't handle her causing damage to the toilet, which seems kind of like a low level to kick somebody out. But it wasn't once, it was multiple times in continuous behavior. And she didn't want her using drugs in her house. Ladies and gentlemen.
Okay, any weapons at the residence? She's got plenty of knives, but she's fucking crazy.
Not she's got a knife in her hand, she's got plenty of knives. She says my client's the one who's cussing at her, but you couldn't hear that on the 911 call. You hear her cursing. And the prosecutor would have you believe that somebody got so upset about kicking someone out of their house that they chased them down with a knife, a dagger, chased them down with a dagger, walked after them with a dagger, threatened them with a dagger over a modem. I'm sure everybody's heard of the, and I'm gonna butcher the name, the Occam's razor. The simplest solution is usually the correct one. What's gonna make you mad? Someone plugged the toilet and you kick them out? Or, and sadly, during the early days of COVID, someone says you can't live in my house anymore. You gotta go. I can't have you doing stuff like that in my house. I can't have you doing drugs in my house. Now, ladies and gentlemen, my client doesn't get up on the stand and put on the waterworks. That's not my client. But you could see true emotion out of her. If she wanted you to buy into this made-believe story about some fantastical knife that the cops searched the house and couldn't find, and you will note, and the judge will instruct you, the officers who did this aren't here. And you are allowed to presume, and again, she'll read the correct law to you, the judge will. You're allowed to presume that's because they would have hurt his case. And health mine likely would be the alternative to that. Ladies and gentlemen, her story doesn't add up because it's different. Because what's easier, telling a consistent truth or trying to remember what you lied about previously? Now, again, like I said before, you have the three options, ladies and gentlemen. You can believe what she said, despite her inconsistencies, despite the changes in the story, despite the fact that you could hear the call yourself. Ignore the tears and the exaggerations and listen to my client's words. You can hear my client tell her you have to leave. Stop calling me names. You've got to go. Not I'm going to stab you. Not I'm going to cut you. Not threatening her. Get out. It's completely different than what she says. You can hear it. It's hard to hear it because she's not screaming. She's talking to her. I can tell you, I had to crank it all the way as loud as I could get it, but I could hear it. And you could hear her say on the 911 call, "You've got to go." Not "I'm going to kill you," which she said, which Pam claimed during the entirety of the 911 call. My client continuously screamed, "I'm going to fucking kill you." Did we hear any of that in the 911 call? Did we hear anybody screaming in the 911 call? Well, we did. We heard Pam screaming. Ladies and gentlemen, instead, you can believe my client. A consistent version of events, which despite the prosecutor's attempt to impeach her, she did tell the police that night. It's in the report. It refreshed her memory. She remembered telling them that. She was confused because, again, she read the report with me in my office 3 years ago, or 2.5 years ago. Did she remember telling the cops that night? No, but when I refreshed her, she sure did. Yes, she did. That's uncontroverted. Her story has been the same from day one. Why? Because it's easier to tell the truth. It's hard to remember when you change your story and you lie and you keep making stuff up. It's easy when you just say what happened, what really happened that night. So if you do believe my client's testimony and you do believe my client's recitation of the facts, I'm not going to say story because it's not a story, it's a recitation of what happened, then you absolutely should come back with a not guilty verdict. But again, there is that third possibility where you're going, man, Pam's waterworks really had me kind of pushed over the edge. Maybe. Although, you know, Yvonne's been consistent. She hasn't changed her story. She's told the cops what was going on that night. I heard the 911 call, and while Pam was crying a lot, I didn't hear any threats that were alleged to have occurred. I heard her say, "Get out." So I know I can hear Miss Hartman, Yvonne, on the phone, but I didn't hear "I'm going to cut her, I'm going to stab her, I'm going to gouge her." And Pam, boy, she changed her story completely about when this assault occurred. At least she admitted the chair thing. If you don't know, that's still a not guilty, ladies and gentlemen. That's called beyond a reasonable doubt for a reason. It has to be beyond that. It can't be a maybe. And I'm confident in you after having listened to this testimony today, after seeing the different versions of events, after seeing all the changes in the complaining witness's story, but you'll go back and you'll vote and find my client not guilty, because she's not.
Yes, please, Your Honor. Thank you. Let's talk about red herrings for a moment. Let's talk about the path the defense wants you to go down. Defense is brought up multiple times claiming that Pam was using drugs. Let's talk about that red herring. Pam is not on trial here. Pam is not on trial. defense wants you to believe that this whole thing might not just be about a toilet. This whole thing might be about drugs as well. But Pam's not on trial. The person on trial is the defendant, because the defendant took a knife and the defendant was mad. And the defendant was upset and went and got a knife. She couldn't let it lie. The defendant could not leave it alone. Beyond a reasonable doubt. It's just that. It's a doubt that's reasonable. After hearing everything, ladies and gentlemen, there should be no reasonable doubt in your mind what happened. You heard from both parties. You heard the 911 tape. And at the end of it all, the judge is going to give you an instruction that says it is not necessary that there be any other evidence other than the testimony of the victim. So if you believe the testimony of the victim, and you believe that beyond reasonable doubt, there doesn't have to be anything else. There doesn't have to be marks. There doesn't have to be a found knife. There doesn't have to be any of that. If you believe the facts that she told you, if you believe what she said, then that's it. If you believe it beyond a reasonable doubt, that's it. Nothing else is needed. Ladies and gentlemen, off of that, I would ask that you come back guilty. I would ask that you come back guilty.
All right, and I will also put this mention as a compliment.
Okay, ladies and gentlemen, you can turn your attention to the screen again for our final instruction. Members of the jury, the evidence and arguments in this case are finished, and I will now instruct you on the law as it applies in this case. Remember that you have taken an oath to return a true and just verdict based only on the evidence and my instructions on the law. You must not let sympathy or prejudice influence your decision. As jurors, you must decide what the facts of this case are. This is your job and no one else's. You must think about all the evidence and then decide what each piece of evidence means and how important you think it is. This includes whether you believe what each of the witnesses said. What you decide about any fact in this case is final. It is my duty to instruct you on the law. You must take the law as I give it to you. If a lawyer says something different about the law, follow what I say. At various times, I have already given you some instructions about the law. You must take all of my instructions together as the law you are to follow. You should not pay attention to some instructions and ignore others. To sum up, it is your job to decide what the facts of the case are, to apply the law as I give it to you, and in that way, decide the case. A person accused of a crime is presumed to be innocent. This means that you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that she is guilty. Every crime is made up of parts called elements. The prosecutor must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove her innocence or to do anything. If you find that the prosecutor has not proved every element beyond a reasonable doubt, then you must find the defendant not guilty. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It is not merely, an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful and considered examination of the facts and circumstances of this case. Every defendant has the absolute right not to testify. When you decide the case, well, that doesn't apply, we should have pulled that because she testified. When you discuss the case and decide on your verdict, you may only consider the evidence that has been properly admitted in this case. Therefore, it is important for you to understand what is evidence and what is not. Evidence include only the sworn testimony of witnesses, the exhibits admitted into evidence, and anything else I have told you to consider as evidence. Many things are not evidence. You must not, or you must be careful not to consider them as such. The fact that the defendant is charged with a crime and is on trial is not evidence. The lawyer's statements and arguments are not evidence. They are only meant to help you understand the evidence in each side's legal theory. You should only accept things the lawyers say that are supported by the evidence or by your own common sense and general knowledge. The lawyer's questions to the witnesses and my question to the witnesses are also not evidence. You should consider these questions only as they give meaning to the witnesses' answers. My comments, ruling, questions, and instructions are also not evidence. It is my duty to see that the trial is conducted according to the law and to tell you the law that applies in this case. However, when I make a comment or give an instruction, I am not trying to influence your vote or express a personal opinion about the case. If you believe I have an opinion about how to decide the case, you must pay no attention to that opinion. You are the only judges of the facts and should decide this case from the evidence. At times during the trial, I have excluded evidence that was offered or stricken testimony that was heard. Do not consider those things in deciding the case. Make your decision only on the evidence that I let in and nothing else. Your decision should be based on all the evidence regardless of which party produced it. You should use your own common sense and general knowledge in weighing and judging the evidence, but you should not use any personal knowledge you may have about a place, person, or event. To repeat once more, you must decide this case based only on the evidence admitted during trial. As I said before, it is your job to decide what the facts of this case are. You must decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything a witness said. You are free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a witness's testimony, you must set aside any bias or prejudice you may have based on race, gender, or national origin of witness. There is no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might distract the witness? Does the witness seem to have a good memory? How did the witness look and act while testifying? Did the witness seem to be making an honest effort to tell the truth, or did the witness seem to evade the questions or argue with the lawyers? Does the witness's age or maturity affect how you judge his or her testimony? Does the witness have any bias, prejudice, or personal interest in how this case is decided? Have there been any promises, threats, suggestions, or other influences that affected how the witness testified? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about the other evidence in the case? Sometimes the testimony of different witnesses will not agree, and you must decide which testimony you accept. You should think about whether the disagreement involves something important or not, and whether you think someone is lying or simply mistaken. People see and hear things differently, and witnesses may testify honestly, but simply be wrong about what they thought they saw or remembered. It is also a good idea to think about which testimony agrees best with the other evidence in the case. Sorry, we have paper thin walls. However, you may conclude that a witness deliberately lied about something that is important to how you decide the case. If so, you may choose not to accept anything that witness said. On the other hand, if you think the witness lied about some things but told the truth about others, you may simply accept the part you think is true and ignore the rest. The elements of the crime of assault, again, the defendant is charged with the crime of assault. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant either attempted to commit a battery upon Pamela Hartman or did an act that would cause a reasonable person to fear or apprehend an immediate battery. A battery is a forceful, violent, or offensive touching of the person or something closely connected with the person of another. Second, that the defendant intended either to commit a battery upon Pamela Hartman or to make Pamela Hartman reasonably fear an immediate battery. An assault cannot happen by accident. Third, at the time the defendant had the ability to commit a battery, appeared to have the ability, or thought she had the ability. The prosecutor must also prove beyond a reasonable doubt that the crime occurred on or about May 21st, 2020 within the city of Lansing, Ingham County. When you go to the jury room, you may take a written copy of the jury instructions with you along with your notes. You should first choose a foreperson. The foreperson should see to it that your discussions are carried out in a business-like way and that everyone has a fair chance to be heard. During your deliberations, please turn off your cell phones or other communication equipment until we recess. A verdict in a criminal case must be unanimous. In order to return a verdict, it is necessary that each of you agrees on that verdict. In the jury room, you will discuss the case among yourselves, but ultimately each of you will have to make up your own mind. Any verdict must represent the individual considered judgment of each juror. As you discuss the case, you should think about all my instructions together as the law you are to follow. It is your duty as jurors to talk to each other and to make every reasonable effort to reach an agreement. Express your opinions and the reasons for them, but keep an open mind as you listen to your fellow jurors. Rethink your opinions and do not hesitate to change your mind if you decide you were wrong. Try your best to work out your differences. However, although you should try to reach an agreement, none of you should give up your honest opinion about the case just because other jurors disagree with you or just for the sake of reaching a verdict. In the end, your vote must be your own and you must vote honestly and in good conscience. Possible penalty should not influence your decision. It is the duty of the judge to fix the penalty within the limits provided by the law. If you want to communicate with me while you're in the jury room, please have your foreperson write a note and give it to my court officer. It is not proper for you to talk directly with the judge, lawyers, court officers, or other people involved in the case. As you discuss the case, you must not let anyone, even me, know how your voting stands. Therefore, until you return with a unanimous verdict, do not reveal this to anyone outside the jury room. When you go to the jury room to deliberate, you may take your notes and you'll have a copy of my full instructions. If you want to look at any of or all the reference documents or exhibits that have been admitted, just ask. I think we just have one video that was admitted, correct? Audio, that is. When you go to the jury room, you will be given a written copy of the instructions that you have just heard. As you discuss this case, you should think about all my instructions together as the law you are to follow. You may return a verdict of guilty of the alleged crime or not guilty. I have prepared a verdict form listing the possible verdicts. The prosecution has introduced evidence of the statement that it claims the defendant made. Before you may consider such an out-of-court statement against the defendant, you must first find that the defendant actually made the statement as given to you. If you find that the defendant did make the statement, you may give the statement whatever weight you think it deserves. In deciding this, you should think about how and when the statement was made and about all the other evidence in the case. You may consider the statement in deciding the facts of the case and in deciding if you believe the defendant's testimony in court. Facts can be proven by direct evidence from a witness or an exhibit. Direct evidence is evidence about what we actually see or hear. For example, if you look outside and see rain falling, that is direct evidence that it is raining. Facts can also be proved by indirect or circumstantial evidence. Circumstantial evidence is evidence that normally or reasonably leads to other facts. So taking that same example, if you see a person coming from outside wearing a raincoat covered with small drops of water, that would be circumstantial evidence that it is raining. You may consider circumstantial evidence by itself or a combination of circumstantial evidence and direct evidence can be used to prove elements of the crime. In other words, you should consider all evidence that you believe. You may consider whether the defendant had a reason to commit the alleged crime, but a reason by itself is not enough to find a person guilty of a crime. The prosecutor does not have to prove that the defendant had a reason to commit the alleged crime. He or she only has to show that the defendant actually committed the crime and that she meant to do so. The defendant's intent may be proved by what she said, what she did, how she did it, or by any other facts and circumstances and evidence. You should not decide the case based on which side presented more witnesses. Instead, you should think about each witness and each piece of evidence and decide whether you believe them. Then you must decide whether the testimony and evidence you believe proves beyond a reasonable doubt that the defendant is guilty. Officer DeJare Davis and Officer Caitlin Miller are missing witnesses whose appearance was the responsibility of the prosecution. You may infer that these witnesses' testimony would have been unfavorable to the prosecution's case. Witness provided a non-responsive testimony to which there was an objection, and I had stricken the testimony, so I'm going to remind you that you've heard testimony from a witness, Pamela Hartman, that was objected to by defense counsel as non-responsive. That the objection was sustained by this court, and so that testimony should be disregarded as non-responsive. To prove this charge, it is not necessary that there be evidence other than the testimony of Pamela Hartman if that testimony proves guilt beyond a reasonable doubt. Okay, ladies and gentlemen, we'll get you a copy of my complete instructions. Mr. Bigelow, I'm going to swear you in so that we can have a recess for them to deliberate. Do you solemnly swear that you will, to the utmost of your ability, keep the persons sworn as jurors on this trial from separating from each other, that you will not suffer any communication to be made to them until deliberations or a verdict have been agreed upon, so help you God?
I do.
Thank you. Any additional matters before they? Oh, I forgot. We got too many jurors.
Yeah, no idea, over my head.
There you go, you, somebody's number out of here. One of you all do not have to deliberate. And that'd be juror number 3. Thank you. Oh, I know. Thank you for your service. You will not have to go into the jury room to deliberate. You are released from your service. Thank you, sir. Other than that, we'll all rise for deliberation.